Let me ask you a follow-up on that, if I may, Judge Bacharach. You mentioned that that the oral argument does change your mind oftentimes, and I wonder. Probably, I'm just going to assume some of those times maybe there was an argument raised on oral argument that was maybe not developed as well as it could have been in the briefs. But I wonder if there was a time when the briefs were just fine. The arguments were all there. It was just maybe there was something, a different kind of expression to the same argument that was made an oral argument that made the difference. Are there cases where there are not new arguments? Because obviously, if it's a new argument, you're not supposed to raise it at oral. But maybe there was just a different expression or spin or mood of that argument that was offered during the hearing. Is that the case sometimes?
Absolutely, Tim. And many times it will be something that it's the same argument. As you mentioned, you really can't present new arguments in oral argument that weren't raised in the briefs, but oftentimes, it will be the same argument, but you're listening to it with fresh ears. And it's sometimes the way, and it may be sometimes, this has happened quite a number of times, Tim, where I listen to an argument and it'll hit me that I had misevaluated what the argument was. I thought that they were saying that there was not enough evidence to support a conclusion in what they were actually saying, and they might clarify it. No, we're saying that there might very well have been, but the judge just didn't adequately explain it. And maybe it was a review from an administrative decision, and that there was just an inadequate explanation as opposed to insufficient evidence to support it. So sometimes there's just a clarification of the argument, and then I'll go back and reread it, and I'll realize, yeah, I misread it, and I now see, yeah, there is enough evidence for it, but yeah, there's an inadequate explanation. So sometimes it just runs the gamut. Or sometimes it's just listening to the same thing that I have already thought about.
What about
hear it with different ears?
Yeah. What about this as another possibility? Maybe the appellant just simply raised too many arguments in the brief, and it didn't get as much focus because maybe you thought that the case should be decided on issue A, but actually issue C, on second thought, when it was raised again at oral argument, really is the dispositive issue in the case.
And that kind of thing does happen a lot. I might look at something and think, oh, there's no final order here, and I'm a fallible human being, Tim, and so I may look at that and say, I'm really getting they argue in the alternative, X, but say the appellee argues that there's no appellate jurisdiction. In the alternative, they argue the merits. And I think, oh, they're absolutely right. There's no appellate jurisdiction. And then something that I learn about in oral argument, something has been rescinded or whatever it is. And I realize, oh, now, even though I've studied it, I had a distorted lens when I was studying the merits, because all along I thought that I was going to vote to dismiss for lack of appellate jurisdiction. And now I realize, no, we very much have to deal with the merits. And so it may be very much something like that. There's just a variety of different things that we hear that will influence us. And like I say, a lot of times these are just sort of the catapulting us into conferencing, where we continue with the discussion from the issues that we discuss in oral argument. And so we get really far into it. And, we all do try to listen both to the advocates and to one another, because we do really try to keep in mind that it is not about us. It's really about trying to get the decision correct.